SJC-13091, Commonwealth v. William McDermott.
Great. Attorney Barnwell.
Good morning. May it please the court, Hayne Barnwell on behalf of William McDermott. I just want to make sure that you can hear me all right. Okay. In Nash, this court held in part that because the COVID-19 pandemic changes so quickly, courts must weigh factors like the absence of active cases in a facility with great caution. And
too far down the road on Barnwell, Ms. Barnwell, before you go too far down the road on Nash.
yes.
Very impressive in your reply brief that you were able to respond to Pope as quickly as you did and Harris as quickly as you did. Thank you. But as you know, we're not simply dealing with Nash here. We're dealing with extraordinary circumstances and Charles here. So my first question is, without the benefit of Harris and Pope, Judge Milkey did a pretty darn good job. But what does extraordinary circumstances mean? He referred to it as special circumstances. And how do you differentiate extraordinary circumstances from likelihood of success on appeal?
I believe when he was, I obviously don't know what he was thinking when he said special circumstances, but he did cite to Charles. So he knew that Charles spoke specifically about extraordinary circumstances. And so I think that there is a procedural difference so that this court could just procedurally dispose of this issue because unlike in Harris, Pope, and Hamilton, the single justice did find special circumstances. He did find a reasonable likelihood of success. And because he found a reasonable likelihood of success on appeal, he found, again, unlike the other cases, that cast doubt, pursuant to this court's decision in Harris, that casts doubt on the justice of this conviction. If you're going to review it beyond the sort of procedural difference and you're going to go more substantively on this issue, there are extraordinary circumstances here beyond the COVID-19 pandemic. He is particularly vulnerable to COVID-19 for one, and for two, this is not your garden variety error that the single justice homed in on. This is about a prosecutor riling up anti-gay prejudice to get the jury or to persuade the jury to discredit both Mr. McDermott but especially the critical defense witness, Peter Werner, who corroborated some details of Mr. McDermott's testimony. This is the only case.
In that regard, because Charles is dealing with the implications of Annie Dukin and is clearly talking about issues beyond the particular case when we're talking about extraordinary circumstances. When Judge Milkey is talking about special circumstances, he seems to be referring to concerns in a closing in 1982, and I'll agree with you. It's striking to read some of the comments. I'll just make one reference to it. It's like an adultery plus comment that's going on, and I hear you loud and clear on that issue. But we really haven't faced what extraordinary circumstances means. And a lot of your argument seems to be that, well, we really would have a good chance on appeal. And that can't just be what extraordinary circumstances is, because that's just one of the factors in Rule 6.
Understood. I think, well, let me get to the substance of it and then I'll pose it. Now that I've thought about it more, even since the reply brief, I want to ask for an alternative remedy here. As for the substance, in Charles, if you go look at Charles, they cite to a case, I believe it's Blankenberg. And in Blankenberg, it talks about extraordinary circumstances in terms of, in other words, in my mind, it's like, this isn't a garden variety error. It goes to the function, the maintenance of the court's authority. And I think that you can view this error in that way because, especially the homophobic tainting this trial because it hits at the integrity of the entire system. If the courts never, from start to finish, from 1982 to 2021, if the courts never remedy or even really address anti-gay prejudice infecting a trial, that hits at not only the integrity of the system, but the court's main function, which is to provide both justice and equality under the law. And I don't know if your honors had a chance to review, listen to the Superior Court's hearing, but I did talk about that. I'm like, this is just, I mean, it really smacked me across the face, frankly, when I first read the prosecutor's closing argument. I thought to myself, even for 1982, this is outrageous. And it went completely unremedied.
Let me take a step on this issue, because again, I don't know how you got it in so quickly, but in the reply brief, I think you have reference to in Nash, we obviously talk about the pandemic situation can never hurt the defendant in a state situation. But in Harris, we talk about the pandemic is not extraordinary circumstances for the purposes of our case. Obviously, it's extraordinary circumstances, the pandemic, but what we mean by extraordinary circumstances. Nonetheless, we do say that it could be, the pandemic could be a plus for the purposes of extraordinary circumstances,
Yes.
right? So then you go to Judge Milkey's findings, and again, this is interesting, not findings, his memorandum in order. He says, I agree with the judge that concerns do not require a different result given the defendant already now both has had COVID-19 and has been vaccinated. And I really don't know how to take that, because the fact that somebody's had COVID-19 or been vaccinated, that can't be a negative. It can't hurt the person requesting a stay. On the other hand, he's saying that he agrees that such concerns don't require a different result, which might mean that he's saying, okay, it's not a negative, you're just not getting a plus here. And I don't know what that means. Maybe you can help me, and if you can't, do we need clarification?
I unfortunately cannot help you because we did not get a hearing. And that's where I was going to go with the alternative, Your Honor. If this court is understandably hesitant to do a final ruling on his motion to stay, then for that reason or any other reason, then you could remand it with whatever guidance this court has about, for example, the COVID-19 factor, which is, of course, mainly before the court today, and where a person has been vaccinated or has had a prior infection. Sort of give the single justice that guidance, and then say, now with that guidance, what did you mean, or come up with a more clarifying decision with that guidance in mind is what I would suggest as an alternative.
Thank you.
Yes. But going to the main, unless there are any other questions about that, I would turn to the main issue before the court, that because the COVID-19 pandemic changes so quickly, courts, as this court held in Nash, factors like absence of active cases in a facility must be with great caution, only in appropriate cases. And this court should hold the same where an incarcerated person has suffered COVID-19 infection or has been been vaccinated. Mr. McDermott's case is not an appropriate case to use his prior infection or his full vaccination negatively against him for three primary reasons. One is the CDC itself states, we don't yet know how effective the vaccines are for people with weakened immune systems like Mr. McDermott. Two, the CDC also states that we don't know how long any immunity conferred by vaccination lasts. And third, other uncertainties abound due to the sharp decline in the vaccination rate, around half of DOC staff's refusal to get vaccinated, and the fact that the coronavirus is rapidly mutating and producing variants of concern, at least several of which appear to make the vaccines less effective. If the
Is
So
it-
C,
that was the question I had was, those three things are absence of information, right? We don't know. And I'm wondering how the third factor, in your opinion, works when there's an absence of information.
when there's an absence of information, then there's still
You seem to
risk.
suggest that we should weigh that as a plus. And I'm wondering why that's consistent with our prior cases.
It's the application of the precautionary principle, which really complements NASH itself. And so in NASH, the court said, maybe the risk is going, or I don't know if it exactly said it this way, but the way I read it is, maybe that instinctive approach is going to be correct, that because there are no current cases in a facility, or the way the facility is set up, it's set up very well ventilated, for example, maybe it will turn out to be the case that no cases come into that facility, but we're still not going to use that negatively against an incarcerated person.
Negatively, I'm wondering why it should be positively used in favor of your client.
Because
I
yes.
don't find any ambiguity in Judge Milkey's order. He cites NASH. He obviously knew the case law and that it can't be used against your client. So I'm going to assume that he, as an appellate judge, applied it correctly. Why, though, should he have applied it positively? He seems to say it's a wash.
He does state it's a wash, but the problem is that Mr. McDermott in particular has a weakened immune system. He's trapped in a congregate
So we
setting.
don't know, given his weakened
Right.
immunity, his prior COVID infection, his vaccination, the environment that he exists in, we don't know if he's at any particular risk. I thought that's what the
Correct.
three things were.
And therefore uncertainty should be a plus, because again, like in NASH, it might even at the time prior to vaccinations, it may very well have been that, for example, NCCI Gardner didn't have cases for months and months, and judges were taking that instinctively, saying, "Look, this is evidence that the risk is basically negligible or completely absent." But then, of course, the coronavirus had other ideas and took over the prison. And so when we do have that level of uncertainty, the benefit of that sort of uncertainty, that risk, needs to go in favor of the incarcerated person.
Isn't the overall goal to be to get less people in this type of setting? That those people who deserve to have stays should be released, so it decreases the number of people in prison?
Yes, that is also an overall goal that this court noted in NASH. That
In a contrary ruling in your case would also create a perverse incentive not to be vaccinated.
yes, that is exactly what CPCS points out in its amicus brief, and I think that's an excellent point. We don't want incarcerated people having this Hobson's choice. Well, get vaccinated, don't get your freedom. Don't protect yourself, but maybe get your freedom. We don't want those sort of perverse incentives.
So in NASH, we say, we don't mean to suggest that every incarcerated individual faces the same danger for COVID-19. Each defendant's risk should be evaluated under the criteria we have outlined. And then let me just add, as Justice Gaziano has pointed out, and I referenced as well, when we look at that, even if there's no cases and everybody's vaccinated, that cannot hurt the defendant requesting a stay. It can never be a negative. That said, we do have to look at the particular circumstances, and as Justice Wendland pointed out, there's certain things we don't know about these circumstances.
Right. So like in NASH, let's say it's a zero. I don't think it is, but let's assume it's a zero. It's a wash, as the Superior Court said. The problem with that analysis and sort of ending the analysis there is that it doesn't plus up the risk for Mr. McDermott. So, and that's what the court was wrestling with there, is that, okay, there's uncertainty, but there are plus factors, right? So I believe it was Mr. Elibert actually was a type 2 diabetic like Mr. McDermott is. And this court noted that pluses up the risk, right? So even though, like, for example, I'm fully vaccinated, but I'm out here in the world. I feel like I can protect myself. Mr. McDermott is fully vaccinated. I'm so happy he is, but he's still in a congregate setting. He still can't physically distance from his cellmate, and all of the other factors that I go through in the briefing.
Okay, any other questions? Thank you.
Thank you very much, Your Honor.
Attorney McGee.
Good, I believe it's still morning, but good morning, Justice Fudd, fellow justices. May it please the court. What is undisputed is that on November 20th, 1981, the defendant shot and killed 38-year-old Robert Kemp while he was at work. He did not return home to his wife. He was shot 11 times with a 9-shot gun. He was buried partially, left by the 18th hole, had his wedding ring, his other rings stolen from him, as well as his wallet, and the defendant fled to Pennsylvania.
There's no doubt, and even putting aside the self-defense issue and the jury instruction and burdens and all that, just putting that aside, no matter how egregious the facts might be, on appeal, there's going to be a review of the closing argument. And so if you look at what Commonwealth versus Charles means in these circumstances after Commonwealth versus Harris and Pope versus the Commonwealth, do we have extraordinary circumstances here, looking at that as it has to be somewhat separate and distinct from the likelihood of success on appeal?
They're focusing on COVID-19 itself. In and of itself, as the court said in Pope and Harris, it doesn't in and of itself present an extraordinary circumstance. And I think, and what I would suggest to the court is that general circumstance, that COVID-19 should be readdressed.
I'm sorry,
should be readdressed. We have made progress as a state.
Before we get there, I'm sorry, before we get there, because we've already said that extraordinary circumstances, it's hard to say because the pandemic is extraordinary and that's an understatement. But as a matter of law, for the purposes of what extraordinary circumstances mean when you have a stay in the collateral appeal situation as opposed to a direct appeal situation, the question before we get to the pandemic, because it can be the pandemic plus,
Correct.
but you got to have extraordinary circumstances. And why isn't the defendant right that the closing is not extraordinary circumstances? Why isn't she right that it is?
As opposed to something like the Annie Dukin.
Yes, well, yeah. Give us your view.
This trial error that's being raised 40 years after the fact. Additionally, the defendant raised these on direct appeal. He raised them in a footnote, and specifically the quotations that defense counsel raises now. And the court addressed them, and on 33 review, reduced the defendant's sentence.
I think that was on extreme atrocity and cruelty with an instruction. You know, Judge Milkey, again, in a very cogent memorandum in order, makes a number of important points, one of which was, I don't have the language exactly, but maybe in the initial appeal, there wasn't a recognition of how, pernicious this might have been.
What Justice Milkey, I believe, said was that this could have laid in wait. And what the Commonwealth would suggest to the court is that this didn't lay in wait. It was addressed at trial. This was a self-defense argument that was based upon the victim being a sexual predator. And that was the central focus of the 183 pages of transcript that the defendant raised, that the defendant and Mr. Warner spoke about. It was addressed by the Supreme Judicial Court in their opinion. They declined to order a new trial. However, on 33 review, as one of the reasons that they reduced the sentence was this relationship that they believed may have existed, and that the facts here did not warrant a new trial. They were admitted to essentially not uncontested facts that he shot and killed the victim in this case. And so this was not something that had laid in wait for 40 years. It was addressed. It was in front of the court. It was in front of the jury. The jury rejected it and convicted him of first-degree murder. So that is the disagreement I would say that the Commonwealth has with Justice Milkey's assessment that this had somehow laid in wait. It was it was eyes wide open. The jury this was in front of the jury. And it was
But this that Judge Milkey it seems to be talking about is, and I understand it may well be was talking about in a chance of success on appeal, which is the first factor under a direct appeal stay. But he's aware of the different standard even before Harris and Pope. He's tuned into that. It seems that he's saying that it's not just that the closing what was addressed before. It's that our consciousness hadn't ripened enough to just hear how bad it is, because there was a suggestion in the closing. I read the whole closing of this is not just accusing him of adultery. There's adultery and you can see there's concerns in the language that's used.
And what I would suggest to the court that and pursuant to Randolph and the substantial risk of a miscarriage of justice standard would be applied by the motion judge in this case. And what I would suggest to the court is that the defendant has that extraordinary circumstance on a motion for new trial hasn't been met here. Not only did he have plenary review, and waived many of these issues. He's argued these in the past. He's argued the self-defense argument. He's also gone before the parole board in 2012 and 2019 and said that all of these issues that he raises were premised upon a lie. He has said this under oath, testified under oath, that he made all of this up and that he worked with his counsel and Mr. Warner to present this case.
Help me out. I understand that if there's ever a motion for new trial allowed, that may well be an admission by a party opponent. But help me out how his statement under oath at the parole hearing that this was all made up factors into our analysis. I'm just not sure I understand, quite frankly, how it does.
I would suggest to the court that that at the very core of a Rule 30 motion is that justice was not done. In this case, how can justice not be done if the defendant premises his entire argument on a lie that he has admitted to, even agreed was a lie 2 weeks before he filed this motion for new trial?
This will be my last question on this issue, but it's important, and I'm not quite getting it, quite honestly. If he did that, it's a horrible thing, no doubt about it. But how does that impact whether the trial he had was a fair trial? It's a serious question. I'm not being rhetorical. Help me out. I'm not sure I understand the connection.
And what I would suggest to the court is that he's arguing that he did not have a fair trial based upon a self-defense argument that he believed that he has now stated was false. So it is contradictory for him to now say that he was prejudiced, that there was a substantial risk of a miscarriage of justice, that he was prejudiced by these errors. One, these errors were created upon if they were errors, that they were created upon a lie. The defendant had a fair trial. The defendant also got the benefit of the Supreme Judicial Court's 33-year review and had his sentence reduced from a first degree to a second degree. He has had 5 opportunities before the parole board. He has had the benefit of Diachenko. He has available to him medical parole. He has all of these things available to him, despite the fact that his self-defense argument was to his own, under oath, and said twice now before the parole board, was based and premised upon something that he coordinated with his defense counsel at trial. And I would suggest, based upon that, it also goes to the risk factor of his flight. Additionally, he's asking the court to essentially take a chance with an individual that has lied before the parole board. Lied before the court. He's testified before the parole board. He's 5 times been rejected by the parole board. He additionally has no ties to the community. His brothers live in California. His parole plan is to go to California.
Well, Judge Milkey agrees with, I think it was Judge Davis, on the security risk, and under Christie and Nash comes to the same position as the trial judge did on the stay. But the defendant is saying that neither of them considered many of the other important enumerated factors as it relates to flight. Neither of them considered a number of the other enumerated factors as it relates to the risk of flight.
And that is why, Justices, this defendant does not have that exceptional plus. He does not reach these other factors. His pattern here, it took him 30 years to tell the parole board what actually happened in this case. And he's asking a trial judge that's hearing his motion for new trial after 40 years of being incarcerated to trust him in society, that he has no ties to the community. He's asking the court to take that chance with somebody that has attempted to be released and has not been permitted. And I would suggest to the court that he doesn't meet any of these, the 3 factors under Nash, and that this court affirm the single justices and the trial court's denial of the defendant's motion for stay. If there's any other questions, I rest on my brief.
Okay, thank you very much, counsel.
Thank you, counsel.